A warm welcome, a warm welcome to our Honorable Director, Professor Dr. Satish Ubade, our esteemed guest of honor, Advocate Sonali Sawant, distinguished faculty members, and the student of Matrix. Dear student, Matrix is committed to enhancing the management competencies of MBA graduates by imparting contemporary knowledge and focusing on the latest advancement in the field of management. In alignment with this vision, our Director, Professor Dr. Satish Ubare, has initiated the four-dimensional lecture series, a distinguished platform that brings together eminent experts from academia and industry to share their insights, thereby enriching students' learning and employability. Today, we are privileged to host our guest of honor, Advocate Sonali Sawant. Welcome, ma'am. She is an accomplished attorney specializing in intellectual property rights, corporate advisory, and technology-driven legal solutions. She is a trademark facilitator and mentor under the Startup India initiative, DPIIT, Government of India, and has successfully handled over 3,000 trademark applications across India and international jurisdiction. Her Her professional journey includes association with leading law firms, where she has advised Fortune 500 companies, startups, and emerging enterprise. Her expertise spans IP prosecution, litigation support, global trademark strategy, and corporate compliance. She has represented clients before India courts and collaborated with international councils on cross-border IP matters. A frequent speaker at national and international forums, she has presented a research paper in Singapore and China and actively contribute to IP awareness initiatives. Alongside her legal practice, she is engaged in pro bono work supporting street child development through an NGO in Pune. So, welcome, ma'am. I invite. Hello.
Thank you, Professor Giri, for the wonderful introduction.
Yeah. I invite all students to turn on their cameras as we will be taking a group photograph. Thank you, Mohit sir. Once again, a warm welcome to Advocate Sonali Sawant. Over to you, ma'am, for the session.
Okay, thank you. Sir, have you made me the admin so that I can share the screen?
Yes.
Okay.
Hello?
Hello.
Yes, ma'am.
Yeah, so how can I share my screen?
Ma'am, you have your presentation in background.
I mean,
You
open?
yes. Uh,
Okay,
so
I'll just open.
you can just click the share button and
Hmm. So in Marathi, we called it as Bauddhik Sampada. Okay, so whatever your mind is going to create, whatever uh, ideas you get, whatever inventions you think, whatever song, whatever drawing, painting, book, song, anything which is original, which is new, which you only are the owner, comes under intellectual property rights. Okay. So in today's session, we are going to see importance and what are the types, what is the law governing such kind of intellectual property rights, why it is important these days. Okay. So we are going to come to know. So by end of this session, you all will at least have the idea, like you will be able to, of course, identify whenever any business idea is going to come, what is patents, trademarks, design, copyrights. Further, also, you being an MBA student, you're going to deal with the management of the company. You are going to be the main decision making. You're going to help the decision makers in how the company should be managed. So intellectual property becomes very important to you because for any company, for any business or any person, their idea is very important. Okay. Yes. Sir, can you take it to next slide, please? Hello, sir.
Yes, ma'am.
Can you please take it to next slide? Because I'm not
Yes.
able to change it from here. Yes.
Okay.
Next slide. Next slide, sir, please. Third slide. So, yes. So as we discussed that intellectual property are intangible assets, just like your tangible assets, creation of your mind. What are tangible assets? Okay, now it is a very technical English word. Tangible assets means whatever we can see and whatever we can touch, we can feel. For example, your house, the chair, the table, the computer, your mobile, your clothes, your books. These are all your assets. It belongs to you. These are tangible. That means you are able to touch it, feel it. But its tangible assets are for the creation of your mind, which nobody can see unless and until you are going to express it in the form of a poem or product or any vehicle, for example, anything which you're going to express it in any form is the intangible assets. So whatever intangible assets are, it will first come to your mind, and then you will start thinking on it. Then you are going to bring it into the intangible assets, which are types of it, like patents, trademark, copyright, designs. Okay. Now these all intangible assets have validity and they are territorial in nature. What does it mean? This means that whatever these rights which government is going to give you for creation of your mind. Okay. For example, if it is going to be an invention, it is going to be a patent. If it is going to be a logo, it is going to be trademark. These all things are you have to register with government of India or in whichever country you are going to go, and then they are going to give you the rights in return of that. These are validity. We are going to see each one what is the exact validity of each of the right, and they are territorial in nature. That means if you're filing this intellectual property rights in India, you're going to get protection only in India. You're not going to get protection internationally. So there is no worldwide intellectual property as such. So if you're filing patent in India, you cannot prosecute it in US. For US, you have to go and file a separate patent application. But in that case, what happens is Indian attorneys cannot file in US. So we have the network of attorneys. So from my profile, you have seen that I have attended various international conferences and all. So that uh, for that, it becomes very important that we have a good connection, good network with international attorneys. So any of our client in India wants to file their intellectual property out of India, we should have the trusted and good contact. Okay. So these all intellectual property basically are territorial in nature. So what are these types of intellectual property? These are patents, trademark, copyrights, and design. We are going to see each one of it in individual. Okay. So please can you take it to next slide? Yes. So why to protect IP? I mean, any the painting which I have created, it's okay now if I do not protect it in during school days or during if anybody is having a hobby of painting, they do not go and protect each and every painting they are doing, or each and every poem they have created, or each and every idea which have come to their mind. Okay, but why you should do that? Because it is the creation. So the brand, the name of your product is the brand of your product. Okay. So it gives you the creation, ownership that you own. That's idea. It gives you market leadership because you are going to pilot it with registry. Okay, with government who are going to give you the ownership certificate. Just like we buy a house, then what we do, we go to the register and then we do the registration procedure. We take that house in our name. The same way, whatever ideas we have created, we have to register it with government in the form of patents, trademark, copyright design, and in that they give you the right. So if you have the specific right, which we call the monopolistic right, that means only you are the owner. Like your phone is in your hand, that means only you are the owner of that phone. The house which you are living, that means only you are the owner of that house. The same way, if you are registering any of the idea, that gives you the market leadership. So you are the only owner of that particular idea, of that particular product. So what happens? This will curb your competition. Nobody will copy exactly your same product. Can own what you create. Of course, it gives you the ownership. Create a fence against infringement suit. So in case anybody copies your idea, then you can take an legal action against them. Why? Because you have the ownership of that product. You have the certificate from the registry, from the government, that this XYZ idea is owned by this XYZ person. Okay. So IP protection can increase the perceived value of products. Have you ever noticed that on the brands which you consume, uh, there is R in superscript on the right side of the thing. So that gives you that the trademark is registered. If you haven't done that, then I'll suggest you from this today's session, you start noticing if there is a patent on that product is written the patent, it is a patented product or patent is under registration. Okay. If there is a copyright, you have seen that C and a circle around it. That shows that it is a copyrighted article or a poem or any literary work. Okay. Unique designs and brands can help you stand out in market. So there are different types of phone and each of the shape is different and it creates the aesthetic value of that product. So that unique product I like, so I buy XYZ product. So that design gives it the appeal to the eye. IP rights can deter unauthorized copying and counterfeiting. Of course, people, if they know that this is a registered brand or this is a patented product, they themselves in 99% do not go and copy it because nobody wants the legal hassle. Sir, can you please take it this page here? IP rights can ensure just above one sentence. Can no no on the yes, fourth page, the whole page, fourth page. Last point is remaining. IP rights can ensure that you receive fair compensation for your work. For example, if you own that uh, 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 idea, then of course the person who wants to purchase it will know that you are the owner. Why he will be able to know? Because you are the owner of it. Yes. So they will come to you, they will pay you XYZ royalty, we say in that case, and then they will purchase it. So you get a fair compensation. Next slide, please. So this is why the protection of IP becomes very important. And then the main hero, the king of IP is patents. Patents is very important because it is one of the important rights which gives you the 100% protection. Why 100%? We are going to come next to the other rights where you will know how those rights are different for patent. So patents are granted to inventions only, new product or new process with inventive step having industrial application. So any product, mostly it goes with electrical, science related inventions. If you are from specific art side or you do a painting, in that there is no invention, there is an originality. So whatever scientific field, mechanical field, electrical field, everything coming under the science are inventions. That invention should be new product or a new process. Okay, it should be a novel one. It should not be an already existing one. That should have an inventive step. Okay, that if XYZ is already into existence, it should be two steps ahead of that existing knowledge, and it should have the industrial application. That means it should be capable of making a product. You just cannot a patent and keep it for your showcase. It should have the industrial application. It should have the capacity to come in the market. So these are the three specific requirements of any invention. So for you, not being from a legal background, you can only think that whenever there is an invention, it should be novel, then only it can be patented. Okay. Now lifespan of this patent is 20 years. So once we file it, we get the registration for 10 years, and post that only for 10 years we can renew it. After 20 years, what happens? That patent comes into public domain. What does public domain means? Any third party can use it now. Okay, so you will be seeing that there are various generic medicine, or already there is an XYZ product and the same is in the industry, because there are high chances that the patent might have lapsed, or its registration might have not renewed, or the registration has been stopped. So what people do when these patents are already expired, but they do again research on it, and they add new points. Those things are done by the existing owners, or any person can come. So there is a directory with the registry where we get to see what which these inventions are, who is the owner, and what exactly the invention is. Okay. Now, a patent is basically a legal grant by the government to encourage innovation, technical development, and economic prosperity. So, what it is, you disclose everything to the government, and they give you a legal grant to use it monopoly individually by yourself. Why this is important? So that you get the encouragement. Arey, this is the thing, this belongs to me. It is one of my property. It promotes the technical development. It gives the motivation to develop more, to upgrade the technology. And of course, eventually, it is going to give the economic prosperity. Second, contract between the inventor and the government for his disclosure of the invention in return of the monopolist right, for a fixed period of time. After that, it comes into public domain. We have discussed this. Active right to exclude others from practicing the invention and prevent others from encroaching on monopoly for limited period of time. So for 20 years, he is the only owner. If anybody copies it, he has the right to take legal action against it. Okay. So for that reason, patents is the king of the IP, because it gives you the specific rights, particularly for what we can say 20 years. Okay. Now, why you will say like why 20 years? Why it is not perpetuity like the other rights we are going to see? Because see, science is always developing and evolving. What today, for example, if you have been using iPhone or OnePlus One was 5 to 6 years back, but today OnePlus 9 RT, OnePlus 14 or whatever phone might be there, the technology is getting updated. Same is with iPhone. Now iPhone 15 is there, 16 Pro is there. We always want to upgrade ourselves. The same way the technology gets upgraded. Once the technology gets upgraded, nobody sees go and see the old inventions. So for that reason, 20 years. And all these things has a fee. Government fees is there. So again, if you want to maintain the portfolio, we have to pay the government fees to the registry. So for that reason, it is for 20 years. So any questions on patents?
No, ma'am, it is
Okay.
clear.
Yes. Okay. So anything, if you have any question, you can put in the Dropbox, message it first. We will discuss it at the end of the session. Okay. So I hope by the end of the session, you will have many more questions once you are able to understand what exactly intellectual property is. Okay. Yeah. Sir, please go to the next slide. Yeah. Thank you. So next is trademark. Now, trademark is basically the brand name. Brand name is the marketing concept, and trademark is the legal name. So, what is a trademark? So, here I would like to give, I mean, you all are from MBA background, mostly might be from MBA marketing background also. So, mostly when I'm working as a trademark attorney, I have a tussle with the marketing department, because what they do, branding and marketing, they come up with the words which are easy. I mean, see, I mean, there is no, this thing with, because you do not have the legal background, you do not know what exactly a brand should be a trademark. Any name can be a brand, but for a brand to be a trademark, it should satisfy the legal requirements given by the Trademarks Act. Okay, so I guess due to that reason, this session is going to be very important to you because when you're going to go in the market and start working, these concepts are going to help you to understand what exactly is your company's requirement with respect to whenever there is going to be some legal or anything. So when the marketing team comes with a brand name, it is very generic. And of course, it will be generic because what is their aim to sell the product, and the customer should be able to understand that product. But what laws say that? Laws say that a trademark should be a distinctive mark, capable of being represented graphically, and should be capable of distinguishing the goods and services from one person of others. So it should not be the same. It should be different from each of the person. Okay. Second thing, it should not bear a quality or quantity. It should not show any directly significance of that particular mark. So of course you cannot use super, wow, nice, good, bad, this kind of adjectives before any of the trademark. It should be a coin word. For example, our law firm name is Progilex. It's a coin word. It is not a dictionary word. It is not. It was not already into existence, but we made the word. For example, pro is like good, so pro, ju, lex is law. Okay, and jura is also law in German. So we have combined this small three words and we have given the identity. When the first day when we decided to adopt this name, nobody was knowing what exactly is Progelec. Many people were not able, even was able to pronounce it. Okay, but eventually after this 3 to 4 years of being in the market, now people know us. Now they know exactly what Progelix is. They are able to pronounce it. So this is the thing which we give to any of the brand names. Whatever we do, so whenever you are designing a marketing campaign or anything, and your team has been faced with form of brand name, unique brand name, which should be sellable in the market, you should be well aware of the trademark because eventually that brand is going to be a trademark. But as soon as the marketing campaign is there, nobody takes this into account. But I'll suggest that whenever any of the products is there and you are coming up with any of the name, first contact your trademark attorney, ask them whether this trademark is available or not, ask them whether it is registrable as a trademark or not. So this will save your time for marketing as well, for the branding as well. And of course, there are a lot of money involved in ad campaigns and everything, flex printing and etc. thing for taking that brand name from your cabin to market. But if in the market when you go and you see, are ye trademark तो already in existence, there is already same name in the market, or are ye register हो ही नहीं सकता है, then the whole thing you have to start again with zero because there are competitors in the market. They will start use similar names with respect to you, and you will not be able to do anything because you do not have a registered trademark. Okay, a trademark bears the goodwill and reputation of the company. So here you see the M of the McDonald's. So this M, anywhere you see, you will be able to identify that this M belongs to McDonald's. So this M is a symbol. This yellow color can also be a trademark. So there are types of trademark. Wordmark, logo, smell, sound. So these are all the types of trademark which we can register. So wordmark will be the standard word McDonald's, but the logo will be the symbol. The color can also be a trademark. The tagline can also be a trademark. Okay. The name Coca-Cola can also be a trademark, and the shape of the goods, the bottle of the Coca-Cola is also a trademark because even if the name of Coca-Cola is not on the bottle, you are able to identify it. अरे ये तो Coca-Cola की bottle है. Why? Because we are so much used to perceive that product कि this belongs to this brand, this belongs to that brand. कि उसका नाम भी नहीं रहेगा, then also we'll be able to identify this product belongs to this brand. So whenever you're going into supermarket, you will see कि अरे similar है सब. हम लाते हैं कुछ मैगी सोच के कुछ प्रोडक्ट, बट घर आके व्हाट वी सी, अरे कलर वगैरह तो सेम है, लेकिन मैगी की जगह टैग ही लिखा है. Okay, so these are the things faced by us as in consumers. So these are called as sub-branded products or counterfeited products. Okay, so that's why a registered trademark and having a knowledge of it becomes very important. TM is used for brand adjacent products and build customer recognition. So even you will see that on any of the brand TM is there. That TM is the product, the trademark is under registration procedure and we own the trade. R is only used for registered trademark. If you use R for unregistered trademark, it is an offense under the trademark. What does offense means? Offense means it is not allowed. For that, there is 3 years of imprisonment. You might get an imprisonment or a fine as well if you are using R on an unregistered product. Okay. Now this trademark is valid for 10 years. The validity we saw for patent, it was 20 years. For trademark, it is 10 years. That means for every 10 years, you are able to renew it. Once you stop renewing it, the protection period will get stopped. So basically, if for infinite years, you can renew your trademark for every 10 years. Got it? So this trademark point I have shared so deeply because it is very important from your perspective if you are marketing student. So please take to next slide. You can put your questions in the chat section so that at the end we'll be able to discuss it. Next is copyrights. Now, copyrights is very common. You all might be aware because in this YouTube era, you might have seen that अरे copyright strike आ गया, ये हो गया, वो हो गया, ये मूवी ने इसके अगेंस्ट कॉपीराइट क्लेम फाइल किया, ये सॉन्ग यूज किया तो कॉपीराइट्स की नोटिस आ गई. So these are all things comes under copyright. So basically, copyrights protects the original artistic work, such as paintings, sculptures, drawings, photographs, and designs, the literary work, everything. Okay. So only original expression of an idea can be protected. So like patents, the main requirement was it should be novel one. For trademark, requirement was it should be distinctive. For copyright, the requirement is it should be the original. So you should be the original author or the owner of the work. Grants exclusive rights to reproduce, distribute, perform, display, and create derivative. So here I would like to give you an example. Like you and your friend is sitting, okay, and you are seeing a sunrise, sunset, and you are painting the sunset. Okay. Now sunset is common to everybody. You and your friend is painting the same sunset, but the drawing of each of your friends is going to be different depending upon your practice, on your skills, on your knowledge. And from among those two paintings, one will be the best one, second will be may also be best one. So does that mean that the person A has copied the painting of person B? No, they both are original creators of the same sunset, which is available to everybody. So that is basically copyright. So you will see कि अरे एक song आ गया तो उससे related अगर now this is was with respect to sunset because it is open to everybody. But this can happen to anything. With respect to song also. But for song it is very strict because वो आएगा तो एक ही के दिमाग में आएगा. एक साथ दो लोगों के दिमाग में नहीं आएगा. And it is very rare cases wherein the same idea is originated from two different people. One can sit in India, one can sit in China. But in this case, who goes and first files the IP, the right gets to them. तो ये बहुत rare to rare cases में होता है, but mostly हो भी जाता है. Okay. So copyright protection is automatically extended when a work is created. A copyright needs to be registered in order to enforce the rights in case of infringement. Now validity. Now copyright protection जैसे ही आप वो drawing या song लिखते हैं, as soon as you create it, the this thing is there. You get the protection. Registration is not compulsory, but we suggest to file so that in case there is an infringement, in case somebody copies you, you should have a proof to show that this work belongs to me. Now, even if you have painted this sunset, is it important to go and file a copyright? In this case, we'll say no. Only if that copyright contains a proprietary information or financial that is going to give you the financial gain, then only we suggest to go and file a copyright. Because copyright is a concept which any person, anyone can produce it. Any person. So during school, children can also write a poem, but they cannot go and copyright it because again there are government fees. Of course, they can copyright it provided their parents are the owner of it because they are minors. But for example, if I am a poet and I am like writing almost 50 to 60 poems, so each poem I cannot go and copyright it. But from that 60, this 10 top 10 are the important. I think यार ये बहुत अच्छी बनी है or this will have give me financial gain, then I can identify these 10 points and I can go and file. If you have money and time, then of course you can file everything. There is no cap asset, but this is a part of strategy which we design for our clients. When they come to us, what should be given importance as per to their budget and as per to their interest. Okay. The validity of this copyright is lifetime of the author plus 60 years. Plus 60 years means what? After the author dies, it is 60 years. So you might have seen कि अभी remix में वगैरह बहुत सारे पुराने गाने आते हैं. Why it is so? Because उसका तो वो पब्लिक डोमेन में आए हैं. ओके, सो पेटेंट्स कॉपीराइट्स पब्लिक डोमेन में आ सकते हैं, ट्रेडमार्क नहीं आता है कभी पब्लिक डोमेन में, बिकॉज इट हैज बीन गिवन द राइट टू गेट रिन्यूड फॉर एवरी 10 years. Okay, so example of copyrights are books, pamphlet, articles, letters, computer program. So even computer software programs, if it is basically a program, SaaS-based product or purely a computer program, it goes under copyright. But if it is having some inventive mechanism using artificial intelligence or this thing, then we suggest patents also. But it totally depends upon case to case. Okay. Yeah. So please take it to next slide. Sir, can you please take it to next slide? Next page, please.
Yes, ma'am.
Yeah, thank you. So next is design. Now design is a fourth type of IP. A design registration or design patent protects the ornamental or aesthetic aspect of a product, such as its shape, pattern, or a configuration. A design registration is called in India. Design patent is called in US. It is a US term, but both the things remains the same. For in India, there is a separate act for design, but in US under Patents Act only design is filed. So it is called as design patent. Now, what exactly design patents protects? The design protects the aesthetic value, the aesthetic aspect of the product, the shape, the pattern, or configuration. So in this case, I have shared the shape of the auto, the shape of the watch, or you will see this bottle. So there are a number of bottles, but each of the shape is different. And we try to shop the products based on how it looks. That is also one of the important aspect whenever we go for shopping. यार ये कैसे दिख रहा है, इसकी डिजाइन अच्छी है, ये वाओ, ये बहुत ही एस्थेटिक लग रहा है. Okay, so that gives the protection under Designs Act. The validity of this design is 10 years initially, and after 5 years, you can extend it. So, total 15 years you get. Now, why only 15 years? Because, again, like patents, the design gets upgraded. जो कल डिजाइन मुझे अच्छी लगी थी वो आज मुझे अच्छी नहीं लग सकती थी, या फिर there might be upgradation in the design as per to the generations. Okay, so that's why the protection given for the design is only 15. Next slide, please, sir. Yeah. So now you are able to understand what exactly are the basic IP. So henceforth, any product you are going to see, each and every product has the IP. Right from the day right from the morning when we get up, what we do, we get up, we on, for example, we on the fan. That fan is also a patent. It is also an IP. Then we brush. That brush is also an IP. Was an idea of somebody. It is also an intellectual property. The toothpaste, Colgate, it is also an intellectual property. So if you have to identify what exactly types of IP is applied to this Colgate, you will see the overall Colgate design and color will come into copyright as an artistic feature. The name Colgate will be trademark. The shape of that tube will be the design, and inside of that paste is the patents. Okay, and the overall getup of this whole product is the trade dress. Trade dress is from, even if this shape is there, this color combination is there, and the Colgate is written, but still you will be able to identify अरे ये तो Colgate का ही डिब्बा है. So that is how we are so much connected with the products around us and the inventions. So whole the right from we get up to go to sleep, wake up to go to sleep, everything we live is in invention only. Okay. I hope you might have got this example. Yes. Next slide, please. Sir, can you please take it to next slide? Yes. So these are the basic important types of IP which has a commercial value. Commercial value means any company or a startup or any business will value that and have to protect that in order to have an upper hand in the market. Other than that, there are geographical indications like Kolhapuri Chappal, Dagdushet Pagdi, then Agre Ka Petha, uh, Paithani, Kashmiri shawl. So these are all Assam tea. So geographical indication, Darjeeling tea. So geographical indications are like trademarks only, but it belongs to the community. Trademark belongs to individual person. Geographical indication belongs to the community. So the person living there will have the organization which is working for this, making this Kolhapuri Chappal, the people over there, they will have an association, and that association will own the GI of that. Why it is important? GI is given on the basis key because of that place or some important aspect of that place, that product has such a good quality. Okay. So Kolhapuri chappal Kolhapur में जो अच्छी मिलेगी, the same if they transport it and export it to other places, then okay. Otherwise, पुनेरी चप्पल में कोई आके कोल्हापुरी चप्पल के साथ मैंने ही ब्रांड निकाला पुणे में बना के, then it will be then infringement of the geographical indication because कोल्हापुरी चप्पल जो है, whoever is producing in the Kolhapur, they should have the license from that organization to use the product. Okay. Next is trade secret. Now, trade secret is like not all information of the businesses should be published publicly. Published publicly means patents के लिए what we do, we share the information. Trademark also we share it. Copyright also we share it. Design also we share it. But सब सर की perpetuity और ये कुछ सालों बाद they come into public domain. So again we have a threat कि कोई तो copy कर ही लेगा उसको या फिर उसमें upgrade करेगा. But some of the information are so secret and so important for the business कि वो किसी को पता नहीं चलना चाहिए. It should remain consistent and safe. तो उसमें trade secret आता है. So in India we do not have any act governing the trade secret. We protect it through non-disclosure agreement, that is NDA. So that is very important कि whenever you are starting a business, you should sign an NDA with any of the person who you are sharing the information. So it shows that you have taken an approximate measure to protect that trade secret. Okay. So to give here the example, Coca-Cola formula of making Coca-Cola is a trade secret. Nobody in the world knows. I mean, only certain person in their organization knows, and that too in bit and pieces. Next is farmers and breeders' right. So the farmers and breeders' right, the act protects the whatever the seed we do the upgradation, hybrid. वो research जो होता है, that type of product will come under farmers and breeders' right. Layout and designs of integrated circuit. I have shown you the image. So the any electronics apparatus having this circuit, that will come under this act because वो भी एक invention नहीं है although, but it is also a creation of mind although उसमें से invention कुछ होता नहीं है patents के according. तो इसके लिए उसको भी अलग सी act दिए हैं हमने. Next is traditional knowledge. Now traditional knowledge is also an IPR which is in public domain. For example, haldi if you apply on skin, it will become we become fair या फिर it is a good immunity booster. Okay, so that is a traditional knowledge. For example, अभी बीच में आपने ये केस सुनी होगी या नहीं पता नहीं कि योगा को यूएस में पेटेंट कर दिया था. Whereas yoga is a traditional knowledge for us. Our generations has been practicing yoga. या फिर the uses of turmeric in प्रोटेक्टिंग अस फ्रॉम कोल्ड, वो हमारे पास तो ट्रेडिशनल नॉलेज है, सबको पता है, लेकिन यूएस में किसी को पता नहीं था तो उन्होंने किया पेटेंट फाइल. तो उसके वजह से व्हाट हैपेंड, हमें उधर जाके वो रोकना पड़ा. वी हैव टू टेक एक्शन अगेंस्ट देम बिकॉज एनीबडी, ऐसे तो वर्ल्ड में पूरा बहुत सारे ट्रेडिशनल नॉलेज है. जस्ट बिकॉज वी डू नॉट नो दैट डज नॉट मीन कि वो हम पेटेंट कर लेंगे. ओके. So that's where the traditional knowledge becomes very important. Next slide, please. So trade secret जो है ना, for any method, formula, device, process, or any information that gives the business a unique competitive advantage over its competition. Again, whatever the information should have these characteristics, then only it can be a trade secret. So it should have a commercial value, then only can be a trade secret. Be known only to limited group of persons and be subject to reasonable steps taken. So commercial value मतलब उसमें से we should gain something financial gain. फिर इसके बाद सबको पता नहीं होना चाहिए कंपनी में, अदरवाइज उसमें तो सीक्रेट कुछ रहा ही नहीं. इट शुड बी नोन टू ओनली स्मॉल ग्रुप ऑफ पीपल एंड रिजनेबल स्टेप्स टेकन मतलब उनके साथ हमने एक प्रॉपर एग्रीमेंट किया है कि व्हाई दे आर should possess that secretiveness and keep that information secret. So mostly we do that through agreements only. Okay. So confidentiality agreements जो हम बोलते हैं NDA साइन करके लेते हैं, it is because of that only. So KFC's secret blend of 11 herbs and spices, Coca-Cola's recipe for the signature drink, these are our trade secret. ये गवर्नमेंट को नहीं दिया है. जस्ट इमेजिन अगर ये इन्होंने पेटेंट फाइल किया होता तो क्या होता. सो मोस्ट ऑफ द तो वो एक तो जो ये है ना, रेसिपीज को पेटेंट्स नहीं मिलता है, कॉपीराइट्स मिलते हैं. तो अगर वो कॉपीराइट्स भी फाइल करते हैं हम, तो वो हम गवर्नमेंट को शेयर करते हैं. तो आफ्टर सर्टेन एक्सटेंट इट कम्स इनटू पब्लिक डोमेन. तो अभी तक वो कोको कोला का जो अपर हैंड है मार्केट में, या फिर केएफसी की जो वो टेस्ट है, या फिर वो मैगी मैगी का मसाला है जो मैगी में डाल के वो टेम्पटिंग बनता है, तो वो तो अभी तो सारे लोग कॉपी पेस्ट कर चुके होते. ओके. बट व्हाट हैज हैपेंड कि वो है मार्केट में, तो पीपल ट्राई टू रिवर्स इंजीनियर इट और सिमिलर इंग्रेडिएंट्स लाके सब ब्रांड्स निकालते ही है. ओके. सो दैट इज द इम्पोर्टेंस ऑफ ट्रेड सीक्रेट. एग्जैक्ट आपको पता नहीं चलता व्हाट इज द सीक्रेट. सर प्लीज टेक इट टू नेक्स्ट स्लाइड. So knowledge and practices handed down through generations within a community. Okay. तो जो हमारे नानी के नुस्खे थे, दादी माँ के, आजीचा बटवा, आजीबाईचा बटवा, these are all traditional knowledge. Traditional knowledge is used to protect traditional techniques and design used in product. While there is no specific IP right for traditional knowledge, it can be protected through a combination of right like copyright, trademark and other IP rights. So for example, ये एक सर्टेन फॉर एग्जांपल हिमालयस पे कुछ पीपल लोग रहते हैं कि उनको पता है कि इस चीज का ये है, तो वो ग्रुप के लिए वो प्रोटेक्ट करके रख सकते हैं कि ग्रुप बना के. नॉट इंडिविजुअल कैन ओन अ ट्रेडिशनल ग्रुप, अ कम्युनिटी कैन ऑफ कोर्स ओन अ ट्रेडिशनल नॉलेज इन द फॉर्म ऑफ वो ट्रेडिशनल नॉलेज का कुछ नाम होगा, तो आप उसको ट्रेडमार्क करके कर सकते हैं, सो दैट नोबडी शुड कॉपी इट. ओके. क्या. सो फॉर एग्जांपल आसाम टी. अभी आसाम टी जो है वो उधर की फेमस है, मैं इंडिविजुअली उसको ट्रेडमार्क नहीं कर सकती बिकॉज इट बिलोंग्स टू सम ऑफ द कम्युनिटी ओवर. व्हाट. नेक्स्ट स्लाइड प्लीज. Next is geographical indication. A GI is a sign used on products that have a specific geographical origin and possess qualities or a reputation that are due to that origin. It indicates that the product comes with a specific location and its qualities are essentially linked to that origin. Okay. GI can be names of a specific place. So GI is basically nothing but it is trademark only. But trademarks, when we say it belongs to individual person, GI belongs to the community. So champagne for wine from Champagne region in France. So region में जो community है उन्होंने उसका trademark लिया है. और broader geographical areas like Parma ham from the Parma province in Italy. So period 10 years and to be renewed every 10 years. So मेघालय गारो textile, मेघालय लिग्नाइट pottery. So ये जो सारे हैं कि वो एक specific community से related है, वो ही उसको ले सकते हैं. मैं इधर आके मेघालय का टेक्सटाइल बना के पुणे में बना के मेघालय के नाम से नहीं बेच सकती. इट इज नॉट अलाउड. Okay. Yes. Next slide, please. Now, whenever there is a idea or a business product, you should be able to map the IP rights. As you know, now after attending this 1 hour session, you are at least you know कि patents भी होता है, trademarks करके भी कुछ नाम है. कॉपीराइट्स मैंने किधर तो पढ़ा है, एंड ट्रेड सीक्रेट्स एग्जिस्ट करते हैं. सो ये नाम सुन के एटलीस्ट यू शुड नो कि अरे ये किससे वी कैन मैप इट. सो इंटेलेक्चुअल प्रॉपर्टी राइट्स. सो पेटेंट्स, इफ यू सी, पेटेंट के लिए टेक्नोलॉजी है. सो टेक्नोलॉजी कैन बी पेटेंटेड, कॉपीराइट्स और ट्रेड सीक्रेट कर सकते हैं. ओके. सो टेक्नोलॉजी जो है, एक तो हम वो गवर्नमेंट के साथ डिस्क्लोज करके पेटेंट्स ले सकते हैं ओनली इफ इट हैज एन इन्वेंशन. इन्वेंशन नहीं है तो मियर कॉपीराइट्स ले सकते हैं, बिकॉज कॉपीराइट्स का क्राइटेरिया इज इट शुड बी एन ओरिजिनल प्रोडक्ट, ओरिजिनल वन. एंड थर्ड, अगर हमें दोनों भी नहीं करने तो वी कैन कीप इट ट्रेड सीक्रेट. Then now is data. If you see data, तो डेटा कॉपीराइट या ट्रेड सीक्रेट कर सकते हैं. डेटा कैन नॉट बी पेटेंटेड. ब्रांड नेम, ब्रांड नेम इट कैन बी अ ट्रेडमार्क, कॉपीराइट और ट्रेड सीक्रेट. आप उसको छुपा के भी रख सकते हैं. ट्रेडमार्क ट्रेडमार्क के अंडर, और कॉपीराइट्स जो है वो आर्टिस्टिक वर्क के अंडर वी कैन फाइंड इट. सो दिस इज बेसिकली टू जस्ट गिव यू एन आइडिया कि कैसे एक एसेट को मल्टीपल आईपी एप्लीकेबल हो सकते हैं. ओके. यस. नेक्स्ट स्लाइड प्लीज. Yes. So to conclude this session, intellectual property is game changer for you. It can either win you or ruin you. So whenever you have a business idea, you should first think of how I can protect this business idea. If you do not think this, then what will happen? You have a very promising idea. You have the idea that can change the industry, वगैरह वगैरह, and you directly come in the market. और वहां पे आके क्या होगा? एवरीबडी विल ट्राई टू कॉपी यू. अगर आप फेमस होते हैं तो आईपी अगर आपके पास है, अगर आपने प्रॉपर स्ट्रेटेजी से उसको रजिस्टर किया है, समझ के लिया है, तो आप क्या होगा, आपका लास्ट तक मोनोपोली मार्केट में बना रहेगा. अदरवाइज क्या होगा, आप डाइल्यूट हो जाओगे मार्केट में. डाइल्यूट निकालेगा, सिमिलर ब्रांड नेम लिख सकता है, सिर्फ एक दो अल्फाबेट्स इधर उधर करके दे कैन यूज इट. सो दैट्स व्हाई आईपी बिकम्स वेरी इंपॉर्टेंट. नेक्स्ट, स्ट्रॉन्ग एंड फ्यूचरिस्टिक आईपी स्ट्रेटेजी प्लेज द इंपॉर्टेंट रोल देन मियर फाइलिंग एप्लीकेशन. तो अभी आपको पता है कि गवर्नमेंट के साथ हमें सारा फाइल करना है, पेटेंट फाइल करना है, ट्रेडमार्क फाइल करना है, कॉपीराइट्स करना है, डिजाइन करना है. लेकिन सिर्फ फाइलिंग ही आपको प्रोटेक्शन देगा क्या? नहीं. इट शुड गेट रजिस्टर्ड, देन ओनली इट विल हैव अ प्रॉपर वैल्यू. सो क्या फाइलिंग है? जैसे मैंने कहा कि मैंने 50-60 पोएम लिखे हैं, तो मैं सब नहीं फाइल कर सकती. मुझे स्ट्रैटेजी क्या करनी पड़ेगी, कौन से 5 है, 10 है, 15 है, 20 है, 30 है, कि जिससे मुझे एक्चुअल कमर्शियल गेन होगा. दैट आई हैव टू आइडेंटिफाई, एंड दैट एप्लीकेशन शुड ओनली गो फॉर फाइलिंग. तो इससे क्या होता है कि हम एक फ्यूचरिस्टिक और स्ट्रैटेजी करते हैं. बिकॉज अगर वी आर गोइंग टू डू एवरीथिंग, तो उसमें हमारा टाइम जाएगा, पैसे जाएंगे और हमारा क्रिएटिविटी जाएगा. तो मेरा कोर क्या है? इफ आई एम अ पोएट, तो राइटिंग पोएम इज माई मेन जॉब. अगर मैं उसको रजिस्टर करते बैठूंगी तो मेरा टाइम तो उधर ही जाएगा. सो दैट्स व्हाई आईपी इनिशियली ही इंपॉर्टेंट है. तो इसलिए अगर आप देखोगे ना, ये स्टार्टअप इंडिया स्कीम है, स्टैंड अप इंडिया स्कीम है, मेड इन इंडिया है, ये सारे प्रमोट करते हैं आईपी को. उनके हर एक कोर में इंटेलेक्चुअल प्रॉपर्टी आता ही है. इवन गवर्नमेंट हैज स्टार्टेड दिस स्टार्टअप इंडिया स्कीम वेरिन you get to register the IP in a very subsidized rate. Okay, if you want to know more information, you can Google it and understand what exactly is the scheme. तो आपके पास कोई सा बिजनेस है, अगर आपको उसके अंडर स्टार्टअप करके रजिस्टर करते हो, तो आपको इंटेलेक्चुअल प्रॉपर्टी रजिस्ट्रेशन का फ्री में सपोर्ट मिल सकता है. सो वाई गवर्नमेंट ने ये दिया आईपी ही पूरे लीगल सिस्टम में. आपको तो पता है कितने लेबर लॉज है. अगर आपको लॉ सब्जेक्ट होगा तो उसमें आपको लेबर लॉज भी होगा, आईपी होगा, जनरल कॉन्ट्रैक्ट्स होंगे, बहुत सारे टॉपिक्स है. उसमें से आईपी ही क्यों गवर्नमेंट ने स्कीम्स में लाया है? बिकॉज आईपी इज द फाउंडेशन ऑफ एनी बिजनेस आइडिया. अगर वो अच्छे से प्रोटेक्ट रहेगा, तो आपका नेक्स्ट 5, 10, 15 ईयर्स जो बिजनेस स्केल अप होगा, वो डबल ट्रिपल उसके बेसिस पे स्केल अप होगा. ओके. सो दैट्स व्हाई अगेन इंटेलेक्चुअल प्रॉपर्टी आपको समझ के लेनी है, एंड प्रॉपर अटॉर्नी के कंसल्टेशन से, स्ट्रेटेजी से आपको वो कैसे फाइल करना है वो भी समझ के लेना है. ओके. नेक्स्ट स्लाइड प्लीज. Yeah. So before leaving this session, I would like to give tips and insights. So कुछ समझ में नहीं आया तो भी ठीक है, लेकिन this 5 things you should know कि do not disclose your ideas to anyone first file patent, because patents जो है वो first to file है. जो पहले मेरे पास आएगा उसको ही मैं पेटेंट होगा. फॉर एग्जाम्पल, इन अ कंपनी, इन अ कॉलेज डिपार्टमेंट में दो फ्रेंड्स हैं, दोनों एक ही प्रोडक्ट पे काम कर रहे हैं, ठीक है। जैसे आपको कॉलेज में कुछ भी ये दिया जाता है, व्हाट आई कैन से, प्रोजेक्ट दिया जाता है। तो प्रोजेक्ट करते करते एक आइडिया मुझे आई और मैंने किया मेरे फ्रेंड्स के साथ डिस्क्लोज, तो उन्होंने भी समझ के लिया। और बाय चांस उसको पता है पेटेंट्स क्या होता है और उसने जाके फाइल किया, तो किसको मिलेगा? राइट, उसको मिलेगा। ऑल्दो वो आइडिया आपको पहले आई थी, बट उसने जाके फाइल किया। सो आपको लगता है कि ये आइडिया मुझे कमर्शियल गेन दे सकती है, फाइनेंशियल गेन दे सकती है, तो इन दैट केस आपको पहले जाके आपके अटॉर्नी से मिलना है, पेटेंट फाइल हो सकता है या नहीं करना है, एंड ऑन दोन ओनली यू हैव टू डिस्क्लोज इट। दिस एग्जांपल वाज विद रिस्पेक्ट टू फ्रेंड्स, बट व्हाट अबाउट रिसर्चर्स? रिसर्चर्स जो होते हैं वो हम पब्लिक पेपर पब्लिश करते हैं, मैगजीन्स में लिखते हैं, जर्नल पब्लिकेशंस में लिखते हैं, पेपर अपलोड कर देते हैं किधर भी, और या फिर इन्वेस्टर्स के पास जाके भी डिस्क्लोज इट। सो नेवर डू दैट। ऑलवेज हैव एन एनडीए, नॉन डिस्क्लोजर एग्रीमेंट विद द इन्वेस्टर, देन ओनली शेयर योर आइडिया विद देम। एंड अगर आपको करना ही है पेपर पब्लिश वगैरह, तो उससे पहले जस्ट सी की पेटेंट फाइल हो सकता है। ओके, नेक्स्ट इज डू नॉट कॉपी अदर्स ट्रेडमार्क और ब्रांड नेम्स, डेफिनेटली। Am I audible? Hello, I'm
Yes,
audible?
ma'am.
Yeah. So second is do not copy others' trademark or brand names. Definitely, वो तो कॉमन सेंस है, आप सबको ही पता है कि सिमिलर नाम से अगर आता है तो क्या प्रॉब्लम होती है। कस्टमर्स गेट कंफ्यूज, डिसाइड है ये एक प्रकार का, और ये इलीगल। ऑलवेज गो फॉर अ पॉइंट एंड डिस्टिंक्टिव ट्रेडमार्क। सिमिलरली आपको आपका ट्रेडमार्क लेके आना है, आपके मार्केटिंग के एफर्ट से, आपके ब्रांडिंग के एफर्ट से, दैट नेम शुड गेट्स इट्स ओन आइडेंटिटी। ना कि ऑलरेडी किसी का सिमिलर उठा के लाया, फिर बाद में पता चला कि अरे ट्रेडमार्क तो हो ही नहीं सकता है, फिर पूरे 5-10 साल उसी में गए हमारे। ऐसे नहीं होना चाहिए। वाई आई एम सेइंग दिस? बिकॉज ये हम डे टू डे प्रैक्टिस में, वर्क में ये फेस करते हैं। ओके, do not publish your design, first file the design application. Similar, it is similar with patents. किधर भी आपको पब्लिश नहीं करनी है, आपको किधर भी किसी को मैन्युफैक्चरिंग के लिए नहीं देना है। अगर दिया तो एनडीए फाइल करो, साइन करो, एंड फर्स्ट गो एंड फाइल द डिजाइन एप्लीकेशन। सेकेंड थिंग इज डू टेक एक्शन अगेंस्ट द इन्फ्रिंजर एंड इलीगल कॉपीराइट, डेफिनेटली। अगर आपको पता है कि कोई मेरी आइडिया कॉपी कर रहा है, कोई मेरा प्रोडक्ट कॉपी कर रहा है, तो आपको उसके अगेंस्ट एक्शन लेनी पड़ेगी। एक्शन लेनी पड़ेगी मतलब क्या? कि आपको उसको लीगल नोटिस भेजना पड़ेगा, आपको उसको एक ये देना पड़ेगा कि आप ये मत करो, अदरवाइज आई टेक अ लीगल एक्शन अगेंस्ट यू। आईपी के लिए पुलिस कमर्शियल क्रिमिनल ये भी अवेलेबल है रेमेडी, तो आप पुलिस कंप्लेंट कर सकते हो, कोर्ट में लेके जा सकते हो। इससे क्या होगा? आज एक इंसान, वन पर्सन इज गोइंग टू कॉपी यू, टुमारो देयर विल बी 10। तो आप अगर एक है तभी उसको ये कर दोगे, तो ये क्या बन जाता है? डेटरेंट बन जाता है बाकी लोगों के लिए कि अरे नहीं, इसको कॉपी नहीं करना चाहिए, इफ आई कॉपी ही इज गोइंग टू टेक एक्शन अगेंस्ट मी। ओके, इसमें और एक क्या होता है कि जब तक कोई कॉपी करता है तो आई एम वेल एस्टेब्लिश इन द मार्केट। जो कॉपी करता है वो तो नया ब्रांड ही रहता है, सो इवन बाय मॉनिटरी दे के नॉट अफोर्ड दिस लीगल एक्शन। सो इट्स ऑलवेज बेटर कि आप उनके अगेंस्ट एक्शन लेके उसको उधर ही स्टॉप करो, सो दैट और 10 कल उठ के आपका ब्रांड कॉपी ना करे। अगर किया तो आप डाइल्यूट हो जाओगे मार्केट में, आपके पास आपकी आइडेंटिटी, आपका मोनोपोली कुछ नहीं रहेगा, जो ऑफकोर्स आपके बिजनेस पे इनडायरेक्टली हैम्पर करने वाला है। ओके, so next slide, please. So this was for today's session. I hope you all got what exactly is intellectual property rights और ये सब क्या है। तो definitely, like, I had a very good time in sharing this IP with you. This is my everyday work, and I thank Mr. Professor Giri for giving me this opportunity. Now we come to the question and answer session. If anybody has a question, please type it in the comment chat section, or you can unmute yourself or raise your hand so that I can give you the chance to ask the question. Yes, come on. Yes, there are total 99 participants, just one less to be 100. How many people are from marketing department, marketing specialization? Raise hand. Good. So definitely I'll recommend them to go and read for trademarks. It will help you in your professional journey. Yes, nice, Srishti. At least you took some efforts and answer to my question. You can take your hand down. If you have any query, you can ask.
Hello, ma'am. Am I audible?
Yes.
I wanted to ask, on a worldwide level, how are all these patents and trademarks and like all the IPs registered, or how a country and or another country gets to know that okay, this particular thing is already registered and you cannot get the patent for it?
Okay, great. Nice question. So basically, like India, in India, we have a free public search for trademarks, patents. Like we say that it is a territorial one, so for only India you will going to get it. But there is a WIPO, World Intellectual Organization. You will see that if every country is going to come with their own individual IP laws, it will be such a chaotic scene. Doing business worldwide will be very difficult. So for that, there is World Intellectual Property Organization. It is one of the body of United Nations, especially formed for regulating this intellectual property. And for that, there are various conventions and treaties. Now, these are a legal concept. I mean, you being a marketing student, you might not be aware कि इंटरनेशनल ट्रीटीज होते हैं बहुत सारे कंट्रीज के बीच जहां पे दे कम एंड एक्सेप्ट यूनिवर्सल लॉस की अभी फॉर एग्जांपल ट्रेडमार्क इंडिया में 10 इयर्स के लिए है अगर चाइना में 5 साल के लिए होगा तो कितना हेडेक होगा फॉर द अटॉर्नी एंड द एप्लीकेंट कि किस कंट्री में कितने साल है वो सब मैनेज करो ओके because in a day-to-day work what happens is कि एक ट्रेडमार्क वी फाइल इन 20-25 कंट्रीज तो हर एक के लिए इंडिविजुअली ऑफ कोर्स वी मैनेज इट बट मोस्टली सबके सेम ही होते हैं लॉ तो इतना होता नहीं बिकॉज ये टाइम बाउंड भी रहता है कुछ कुछ एक्शन जैसे रिन्यूअल करना है ये फॉर्म भरना है वो फॉर्म भरना है विद इन टाइम हमें करना पड़ता है तो ट्रिप्स और पेरिस कन्वेंशन बर्न कन्वेंशन ये इंपॉर्टेंट ट्रीटीज है जहाँ पे सब कंट्रीज ने आके इसको एक्सेप्ट किया है कि जैसे ट्रेडमार्क 10 इयर्स के लिए है पेटेंट्स 20 इयर्स के लिए है डिजाइन 15 इयर्स के लिए है कुछ कुछ कंट्री है जो नहीं करते लेकिन वो रेयर केसेस में जो कि वी कम टू नो आफ्टर गेटिंग टू तो ये वर्ल्ड इंटेलेक्चुअल प्रॉपर्टी के पास पीसीटी है पेटेंट कोऑपरेशन ट्रीटी ट्रेडमार्क्स के लिए मैड्रिड है वहां पे वी कैन फाइल द इंटरनेशनल ट्रेडमार्क्स इंटरनेशनल पेटेंट्स पर इसमें एक फायदा ये है कि one stop solution है from one window we can select multiple countries but those country only which are signatory to that treaty मैड्रिड की जो ट्रीटी है पीसीटी की जो है वो क्योंकि वो कंपल्शन नहीं है ना इंटरनेशनल लॉ जिसको विलिंगली एक्सेप्ट करना है वो ही साइन करेगा एज सच किसी ने किसी को मतलब यूनाइटेड देश जाके किसी को मतलब फोर्स करके नहीं बोल सकते कि आप ये साइन करो voluntarily in
True.
order to have a good business relation import
Mm-hmm.
export अच्छा हो तो कंट्रीज खुद आके वो एक्सेप्ट करते हैं सो वाइपो है उनके भी पब्लिक डेटाबेस है यूरोपियन यूनियन है उनके पब्लिक डेटाबेस है यूके बहुत सारे कंट्रीज के फ्री और पब्लिकली अवेलेबल डेटाबेस है वहां पे जाके भी सर्च इट आई होप योर क्वेश्चन इज आंसर
Yes, ma'am. I have one more question regarding this. So, when we talk about trademarks and the validity is for 10 years, so these big giants like Tata, Reliance, they also are like abide to it. They have to like renew their trademarks after every 10 years.
Of course, everybody. Even today, I own Progilex trademark. Even being a lawyer, trademark attorney, I have filed my trademark. I have registered it, and I have to renew it. Laws are same for everybody. So you took the name of Tata. They have the big portfolio, 500,000, 1,500 trademark portfolio in n number of countries. They have multiple brands. So that's why the working of as a trademark attorney or a IP attorney becomes tedious बिकॉज आपको जो प्रोसिक्यूशन है प्रोसिक्यूशन मतलब फाइलिंग टिल रजिस्ट्रेशन वो अलग वर्क रहता है रजिस्ट्रेशन के बाद वो डेटा मेंटेन करना, इवन वी हैव द वर्क ऑफ पोर्टफोलियो मैनेजमेंट, कि आप आज अगर मेरा प्रोजुलेक्स ट्रेडमार्क रजिस्टर है तो उससे सिमिलर कोई कॉपी नहीं कर रहा है, तो वो मॉनिटरिंग भी हम करते हैं। और आई ये जो मैंने अभी बताया कि जो मोस्टली फ्रीली अवेलेबल पब्लिक डेटाबेस है उस पे जाके, ई कॉमर्स वेबसाइट पे जाके, तो दैट इज कॉल्ड एज मॉनिटरिंग ऑल्सो, सो दैट इज ऑल्सो टू बी कंडक्टेड। सो दैट्स व्हाई आई सेड कि रजिस्टर करके आपको उधर रुकना नहीं है, यू हैव टू टेक एक्शन अगेंस्ट द कॉपी कैट, बिकॉज आपने ऑल्दो रजिस्टर किया है तो कोई आके 100% कॉपी नहीं करने वाला है, उसको एक दो वर्ड्स ट्विस्ट टर्न करके फोनेटिकली सिमिलर या फिर लोगो सेम होगा, नाम अलग होगा, ऐसे करके लोग करते हैं। सो यू हैव टू बी विजिलेंट।
Yes.
Yes.
Thank you.
Okay. Thank you so much. Any other question?
Am I audible now?
Yes.
Okay. So I have a concern that see, Tata Play has regained their name, right? Previously it was Tata Play, and now it's Dutch, right?
Your voice is breaking.
Am I audible now?
Yes.
Okay. So Tata Play have changed their name. Previously it was Tata Sky, and now it has come up to Tata Play, right?
Hmm.
So why are the competitors still using the name Tata Sky?
I mean, this see, कॉपी करना है या नहीं करना है वो इंडिविजुअल के बेसिस पे है, लेकिन this Tata Play should take action against that Tata Sky because they are encroaching upon the goodwill which Tata Play has created till now. तो कैसे होता है कि ट्रेडमार्क की जो आईपी नॉलेज है ये सबको नहीं होती है। टुडे यू हैव अटेंडेड दिस सेशन, गवर्नमेंट स्कीम भी अगर आप देखोगे तो वो कब से आई है, 2015 से। ये जो एक्ट है ट्रेडमार्क का 1999 में आया है, डिजाइन का भी 2000 में आया है, पेटेंट का भी वो 90s में ही आया है। तो इफ यू सी इट्स हार्डली बिन 30 to 40 years कि लोगों को पता है कि ये रजिस्टर भी करना है, तो इसका अवेयरनेस नहीं है, या फिर सम पीपल जानबूझ के कॉपी करते हैं। सो वी डो नॉट हैव व्हाट वी कैन से कंट्रोल ऑन दैट, वी कैन ओनली हैव अ कंट्रोल कि अगर हमने हमारा पता है कि ये मेरा ट्रेडमार्क है, वी हैव टू रजिस्टर इट एंड देन इवेंचुअली वी हैव टू मॉनिटर इट। तो ये वाई जो है इसके लिए ऐसे आंसर नहीं है, बिकॉज इट इंडिविजुअल की जो मतलब फितरत व्हाट वी कैन से, दे हैव टू डू इट। तो उन्होंने किया है तो जो ओरिजिनल ओनर है दे शुड टेक द एक्शन। अभी वो भी कंपलसरी नहीं है, जिसको लेना है वो लेते, नहीं लेना है वो नहीं लेते, लेकिन इसमें क्या होता है, कंज्यूमर्स गेट अफेक्टेड बिकॉज वी थिंक कि अरे ये तो ओरिजिनल का है, लेकिन जाके बाद में पता चलता है ये तो फेक है। यस।
Okay. Thank you.
Thank you, ma'am.
So I hope there
Thank
are
you,
no
ma'am.
other questions from the students.
Yeah.
Okay, fine. No problem.
Thank you, ma'am. Thank you
Thank you,
so much
sir.
for the session.
Thank you, students, for inviting me. I really had a wonderful time. Yes, sir.
Thank you, ma'am.
Dear ma'am, on
Yes.
behalf of Matrix School of Management Studies, I would like to extend our sincere gratitude for your invaluable contribution as a guest speaker on the topic intellectual property rights. Your session was highly informative, engaging, and motivating for all our students. Your insightful
Thank you.
presentation brilliantly demystified the complexities of IPR, transforming abstract legal concepts into tangible, practical knowledge, crucial for our future managers and entrepreneurs. The way you illustrated the importance of patents, trademarks, copyrights, and trade secrets with real world example and case studies was particularly impactful. The interactive question and answer session further enriched the learning experience, addressing the specific queries of our curious students. Your contribution has been invaluable addition to our academic calendar and has significantly further our goal of providing industry relevant knowledge to our students. Once again, thank you for your time, effort, and the wonderful session. We sincerely appreciate you sharing your wisdom with us and hope to have the pleasure of welcoming you to our campus again in the future.
Sure, sure. I would be delighted. Thank you so much. Okay, then, everybody, bye. Hope to see you in offline too. Bye, sir. Should I leave? Okay. Thank you, sir.